Thank you. Now moving on to agenda item 2B, AB 559 Berman. A brief summary for this bill can be found in the meeting materials on page 125. AB 559 would add necessary dwelling units or ADUs to the definition of home improvement in contractor state license law and specify that individuals who violate progress payment provisions causing financial harm to their customers are subject to a $10,000 fine and possible license revocation. This bill received opposition from ADU manufacturer builders concerned about how home improvement down payment restrictions may negatively impact off-site custom builds. The author decided to make this bill into a 2-year bill to see if the opposition's concerns can be alleviated before moving forward. Chief May, can you provide a brief update?
Thank you, Member Barton. So staff met with the lead opposition to AB 559, the Casita Coalition, on November 13th to discuss potential legislative ideas to deter consumer harm from the ADU industry. Some of the ideas discussed included requiring a payment and performance bond or establishing a managed fund control for ADU projects. Aside from legislative fixes, we also discussed how CSLB can improve internal processes aimed at preventing consumer harm, such as updating the ADU video, making CSLB's website more accessible.
Yeah, here's the stakeholders like that.
From industry.
Yes, it seems like it's manufacturers that are the ones pushing back because it's their monies that they would be holding back based on progress, right? Again, back to the same thing, progress, payment, progress. So they're pushing back saying that they don't want to have that regulated per se. They want to have the control of it based on a contract that's being signed, not on the rules that are set for everybody based on production progress.
In speaking to the legislators, is there maybe a decision if there's a bad actor who maybe has transgressed in previous generations of ADUs, that they would fall captive to payment bonds or door control funds as an alternative to, controlling their excessive fees along the way?
Yeah, we could bring that up. I know Chief May and I are planning maybe in February something, meeting with legislators, and that's what we'll bring in.
I mean, you're not painting everybody with a broad brush, right? Does everybody need to be under control funds? Maybe not. Maybe they're bad actors.
Sounds good. Any other comments or questions from the board? Thank you. And any questions or comments from the? Seeing none, thank you. Now moving on to agenda item 2C, SB 291 Grayson. A brief summary for this bill can be found in the meeting materials on page 125. SB 291 was signed into law and will be effective January 1st, 2026. SB 291 increases penalties for filing a false workers' comp exemption. The bill also reinforces the legislator's prior direction for the board to identify the feasibility of establishing an exemption for workers' comp that employs an evidence-based process for determining eligibility first. This bill does not change requirements for all licensees to carry workers' comp insurance and the end of the existing exemption to workers' comp by January 1st, 2028. Staff are not asking the board to take any action on this bill today. Chief May, can you provide a brief update on how CSLB will implement SB 291?
Thank you, Member Barton. So the biggest lift towards implementing SB 291 is determining how CSLB can verify eligibility prior to authorizing an exemption and to report the board's findings to the legislature by the end of 2026. Since the passage of this bill, the Workers' Compensation Advisory Committee and subsequently the Legislative Committee have met to discuss its implementation. The Advisory Committee and the Legislative Committee considered the bill and made the following recommendations. First, hold stakeholder meetings to determine criteria for a possible exemption and prepare a draft report for the legislature to be reviewed by the board. Meet with the State Compensation Insurance Fund, the Department of Insurance, and the Department of Industrial Relations Division of Labor Standards Enforcement to better understand their exemption pre-qualifying criteria and determine if it can serve as a model for CSLB. And also lastly, to determine the feasibility of requiring an application fee to assess initial workers' comp exemption eligibility and a renewal fee to audit and assess ongoing compliance for a workers' comp exemption. This would require staff to conduct a workload analysis to determine the application and renewal fee amounts. Staff will also need to promulgate regulations to reflect the new fine amounts for violations of workers' comp requirements, and will need to update the website and other materials to reflect the changes affecting applicants and licensees. Staff will continue to provide updates at future board meetings on efforts to implement this bill. Back to you, Barton.
Thank you, Chief May. Are there any board members, comments, or questions on SB 291? Seeing none, let's take public comment. Are there any members of the public wanting to comment on SB 291? Thank you. Now moving on to our last board-sponsored bill, agenda item 2D, SB 779 Archuleta. Is a brief summary for this bill can be found in the meeting materials on page 126. SB 779 would establish or increase minimum civil penalties, also known as enforcement fines on citations. This bill also increases CSLB's reserve fund cap from 6 months to 12 months. SB 779 was signed into law and will be effective January 1st, 2026. However, the increased minimum fines has delayed implementation until July 1, 2026 to coincide with the start of the fiscal year. Staff are not recommending any action.
CSLB's website and other materials as needed and disseminate an industry bulletin. And lastly, SB 779 requires staff to promulgate regulations to update the minimum fine amounts already listed in regulation. Back to you, Member Barton.
All right, thank you, Chief Mayor. With this implementation, thanks to the frugality of our registrar folk, we'll be able to, 8 months will be acceptable and even increase that. Are there any board members like to comment or question on SB 779? All right, seeing no further board member comments, let's take public comment. Are there any members of the public wanting to comment on SB 779? And then let's move on to agenda item E3, review, discussion, and possible action on the implementation of non-sponsored bills from 2025. Brief analyses for these bills can be found in the meeting materials starting on page 127. 3 of these 4 bills are simple to implement, so I'm hopeful that we can move through this agenda item quickly. Let's start with agenda item 3A, AB 1002. AB 1002 was signed into law and is effective January 1, 2026. This bill authorizes the Attorney General in a civil action to petition the court to deny licensure or licensure renewal of any contractor or any other qualifying individual on a license for failing to pay workers a full amount of wages they are entitled under the law, not fulfilling a wage judgment, or violating an order regarding payment of wages. The bill requires the AG to notify CSLB before bringing such action and provides authorization for CSLB to intervene or collaborate with the AG in the proceedings. The bill also clarifies CSLB's sole authority to suspend, revoke, or deny licensure or licensure renewal if the AG and/or CSLB action prevails as provided. Staff are requesting no action on this bill today. Chief May, can you describe staff efforts to implement this AB 1002?
Thank you, Member Barton. To implement AB 1002, enforcement managers will ensure that key enforcement staff are aware of the new law and will update procedure manuals as needed. Also, public affairs staff will issue an industry bulletin to remind licensees to comply with wage payment requirements. Back to you, Member Barton.
Thank you, Chief May. Are there any board member comments or questions on the implementation of AB 1002? Seeing no further board member comments or questions, let's take public comment. Are there any members of the public who are wanting to comment on the implementation of AB 1002? Thank you. Let's move on to agenda item 3B, AB 1327. AB 1327 was signed into law as effective January 1, 2026. AB 1327 requires home improvement contracts to include the contractor's email address and allow for cancellation of the home improvement contract by the buyer via email. The bill requires a home improvement contract to include a telephone number to assist the buyer in locating and filling out the notice of cancellation. The bill also provides that if the notice of cancellation is not included in or attached to the home improvement contract, the buyer may file a complaint with CSLB. Staff are requesting no action on this bill today. Chief May, can you describe staff's efforts to implement this AB 1327?
Thank you, Member Barton. To implement AB 1327, enforcement managers will notify the enforcement staff of the new home improvement contract disclosure requirements and update procedure manuals as needed. Public affairs staff will update the website and other materials to reflect changes, and PO staff will also disseminate an industry bulletin to educate licensees about the changes. Back to you, Member Barton.
Thank you, Chief May. Are there any board member comments or questions on the implementation of AB 1327?
And one question. If the chair, if there is they don't include it in the contract and they file a complaint, would that be considered then a null and void contract if they wanted to cancel?
Requirements, and that can be grounds for disciplinary action. And the second issue is, if you don't provide that information as required, you may have a difficult time pursuing any type of natural restitution to the courts. So civilly, that's what how that would be addressed. If you're going to sue your customer and say that, well, there's two issues. One, they might have received the money, the consumer would have to go to try to recover it, but they could show that they were not afforded the right to cancel the information, and that would benefit them. Administratively, it's a violation. It could also play out in the civil courts.
Thank you. Thank you very much, Sheriff. Any other questions from the board or comments? All right, thank you. Seeing none, are there any comments or questions from the public?
Does that include the timing? Like, is it 3 days, 10 days? Should that be included in there?
That was not altered with this bill, which I'm.
All right, thank you. Let's move on to agenda item 3C, SB 456. SB 456 was signed into law and will be effective January 1, 2026. Staff are requesting no action from the board on this bill today. As we discussed during the executive update earlier on the agenda, SB 456 establishes an exemption from licensure for artists who paint murals. Chief May, do you have anything to add regarding the implementation of SB 456?
Thank you, Member Barton. So in addition to finalizing and distributing the industry bulletin by the end of the year, we discussed it earlier, public affairs staff will update CSLB's website and other materials as needed to reflect the new exemption. Also, enforcement managers will notify enforcement staff of the new exemption and update procedure manuals as needed. Back to Member Barton.
Thank you, Chief May. Are there any board member comments or questions on the implementation of SB 456? Seeing none, we'll move on to public comment. Questions? If there's any members of the public wanting to comment on implementation of SB 456? Seeing none, thank you. Let's move on to agenda item 3E, SB 517. SB 517 requires contractors to disclose the names, contact information, license number, and classification of any subcontractors in a home improvement contract upon request. The bill also clarifies that the prime or direct contractor is ultimately responsible for the construction project. SB 517 was signed into law and will be effective January 1, 2026. Staff are requesting no action by the board today on this bill. Chief May, can you describe staff's efforts to implement SB 517?
Thank you, Member Barton. So SB 517 is also fairly simple to implement. Enforcement managers will make sure that key enforcement staff is aware of the new home improvement contract requirements and make updates to procedure manuals as needed. Public affairs staff will conduct consumer and industry outreach, update CSLB's website and other materials as needed, and disseminate an industry bulletin regarding the new home improvement contract requirements. Back to you, Member Barton.
Thank you, Chief May. Are there any board member comments or questions on the implementation of SB 517?
I just have a question. It has to be the request of the homeowner, but actually, so it's not automatically within their contract.
It will be stated in the home improvement contract that they have the right to ask.
So maybe another, it'd be kind of like two bulletins. One bulletin for contractors with a E2 license saying, hey, you need it on request. And then another bulletin to consumers in California as they get contracts, and if they want to request to subcontractors, then they can actually request it directly with their prime. They won't know, they will never request.
Thank you, Member Warren. Any questions or comments from the board? Seeing none, any comments or questions from the public? Seeing none. Thank you, and let's move on to agenda item 4. Review, discussion, and possible action on 2026 proposed legislation. Staff have 2 legislative proposals for your consideration today. By sponsoring these proposals, the board will authorize staff to find a legislator to carry legislation on behalf of CSLB. I'll pass this over to Chief May to describe the first proposal, agenda item 4A, related to debris removal during a declared disaster.
Thank you, Member Barton. So the first legislative proposal for the board's consideration today is related to debris removal during a declared disaster. An analysis of this proposal can be found on page 133 of the materials. Before I jump in, this proposal may sound familiar because it was included in a bill supported by CSLB last year, SB 641 FB. SB 641 would have waived certain licensing requirements for programs under the Department of Consumer Affairs during a declared federal, state, or local emergency. Unfortunately, the bill was vetoed by the governor for provisions that the C21 building/moving demolition classification. This proposal would also require licensees to have passed a CSLB hazardous substance removal certification examination and comply with HAZWOPER requirements established by the Department of Industrial Relations to perform debris removal during a declared disaster. By specifying who's authorized to perform debris removal during a declared disaster, including muck out and ash out operations, and requiring that contractors possess sufficient training and certification to conduct debris removal, worker safety is enhanced, and the risk of additional health and environmental hazards resulting from improper debris removal and disposal practices can be mitigated. This proposal does not alter existing law as it relates to debris removal on sites unrelated to a disaster declaration. Staff respectfully requests that the board consider sponsoring this proposal. Back to you, Member Barton.
Thank you, Chief May. Are there any board member comments or questions on the debris removal proposal?
Curious to know why it was vetoed. So the bill was a lot more expansive than this one piece, and my understanding is that it was vetoed because it was overly broad in other areas. It had certain licensing waivers that would occur during a disaster, and that pertains to Department of Consumer Affairs and private programs under it, including CSLB. And then that piece, and there was also some provisions for Department of Real Estate. I think there were issues with that as well. So my understanding from digging around is that it wasn't related to the narrow CSLB portion that we're proposing here today to run with again.
Questions from the board? Seeing none, is there a motion on this bill to support? A second. Second. Any discussion? Right. We have regular move second. Thank you, Katie. Would you please call for the vote?
Miguel Galarza,
We should have public comment before.
That's what I was going to ask Barry.
Please,
And thank you. Then ask for public comment.
public comment on Saturday.
Does that have anything to do with air quality control or asbestos in those situations?
Thank you, sir.
Thank you, Barry. Thank you for noting.
Any board members comment?
Okay, thank you. Would you, Katie, would you please call the roll?
Video Garza,
Aye.
Alan Guy, he has an excused absence. Rodney Phillips,
Aye.
Joel Barton,
Aye.
Amanda Guy, Diane Love, Jacob Lopez, has an excused absence. Michael Martin,
Aye.
Henry Nunn,
Aye.
Steve Pinelli,
Aye.
Joseph Cristiano,
Aye.
Jim Ruane,
Aye.
Thomas Reese has an excused absence. Mary Tiger, motion passes.
Thank you very much. Let's move on to agenda item 4B. I'm going to pass this over to our licensing chief, Para Gagnon, to describe. But first, the analysis for this second proposal can be found on page 136 of the meeting materials.
Thank you, Member Barton. The second legislative proposal for the board's consideration today is related to the reissuance of a license number. Sometimes a construction company will change its corporate structure, transferring its business location to another state, merging with another entity, or changing its business type, like going from an LLC to a corporation. Typically, the business entity will want to retain the original license number to complete any active contracting jobs, and older license numbers are considered valuable in the industry because they show stability. Existing law limits when a license number can be reissued from one company to another for important consumer protection reasons. It is imperative for consumers to know exactly who they are contracting with and that the individuals behind the license and license number are accurate. However, there are ambiguities in the law related to the reissuance of a license number from one corporate entity to another, resulting in CSLB often being unable to transfer the license number. This can cause a license to be placed on suspension to expire or be unable to renew due to a change in corporate registration or status. CSLB sees this most often when a company moves their business address to another state, registers in that state for tax purposes, and then when their California Secretary of State registration ends, the license is canceled. They end up having to apply for a new license and get a new license number because the old entity no longer exists. This leads to a lot of frustration and extra work for the licensed company. Providing clarity in the law about when a license may or may not be reissued or reassigned helps protect licensees from losing long-established license numbers tied to their business reputation and ensures they can continue ongoing construction projects with an active license in good standing. Clarification will also enable staff to better assist licensees in navigating the process of making changes to their business entity. For example, what will happen when moving from domestic to foreign, or when a company buys another company and takes it over? Staff would appreciate the board's support today to pursue this statutory change. Back to you, Member Burton.
Thank you, Chief Gagnon. Are there any board member comments or questions on the proposal to clarify?
Lawyers often they can figure this out, but the ones that don't, the newer ones, the smaller ones are calling us trying to figure out, and we're like, we're licensing staff, we're not lawyers, and it's hard for us to explain it to them. So we like to clarify it in the law so it can be clearer for them, for us, and also reduce the number who are moving to another state for tax purposes. Then suddenly they get this letter in the mail that the license is canceled because their Secretary of State is ended, and we don't want that happening to people.
So would this recommendation be to develop a proposal that we would then review prior to having to be submitted?
Yes. She would come up, well, he would come up with wording for you all to look at and be able to discuss in future board meetings.
Super. We think that license number is one of our biggest assets.
Yes, yes, it is.
It's very important attention to one of the things that kind of people that. So, yeah, corporate restructuring, to your point, has only changed the history of the company.
Yeah, no, I understand that's important.
Thank you, Chief Gagnon. Very short vote.
We're gonna quick comment on that, Carol. So this came about only because of the calls that CSLB receives regarding confusion as to when a number can be reissued. And we don't want contractors to go under suspension unnecessarily. I mean, that's the problem. But also from the license service, so Rick Pierce is there today. I know he's a little bit about it, but we intend to work with the industry and the license services just to provide clarity to the law. So you don't have someone that changed their corporate status to another state, only to find they can't renew, and then they have an expired license.
Thank you for that clarification. Any other board member comments or questions? Seeing none, any comments or questions from the public?
Jamie Cohen, Contractors License Experts LLC, one of the licensing services that I just mentioned. I'm not quite sure what kind of clarification we proposed for the specific EC 7075.1, but I just feel like the law, the code as it currently stands does already provide for when a license would be allowed to be reissued. And then on the board's website too, it does actually specify the steps that the applicants need to take to reissue the license. So on the website currently, it says you must submit a written request for license reassignment, specifying which condition exists. For example, parent corporation has merged or created a subsidiary, or the subsidiary has merged into the parent corporation, along with an original application for a contractor license and requiring fees. So as long as an applicant follows those steps, and the current BPC allows for that, and they're able to show that proof. For example, with the Secretary of State, there's documentation that they have to submit to do the merger, which one is the subsidiary, which one is the parent company, et cetera. I believe that the public should be allowed to continue with that, because as Mary Tygart had mentioned, that license numbers are usually, especially older ones, are very important for the new entity that's taking over, as long as they meet the requirements, of course, and they follow the application process.
Yeah, thank you for that, Chief. I think that's to further codify that, right? That's what you-
Just want to clarify it.
Thank you very much for your comment. Any other comments or questions from the public? Great, seeing none, then I'll ask for a motion to support this recommendation.
Make a motion to support this recommendation.
The recommendation is to have,
Staff.
let staff create language proposed and bring back to the board for potential legislation.
Second. Any comments? Katie, would you please call the roll?
Miguel Galarza.
Aye.
Alan Gott, has their excused absence. Robbie Cobos.
Aye.
Joel Barton.
Aye.
Amanda Gaio. Diana Love. Jacob Lopez has an excused absence. Michael Marr. Henry Nunn. Steve Pinelli.
Aye.
Joseph Preciado.
Aye.
Jim Wayne.
Aye.
Thomas Reese has an excused absence. Mary Tygart. Aye. Motion passes.
Thank you very much. All right, and the last item on the legislative agenda item today. Agenda item 5, review, discussion, and possible action on 2026 proposed non-substantive updates to contractors state license law. Agenda items 5A through D are proposed non-substantive updates to contract. Because this bill deals with more programs than just CSLB, any proposals included should be non-controversial, minor, and no cost. The omnibus bill provides CSLB with a valuable opportunity to identify and correct errors or inconsistencies within contractors law, therefore minimizing confusion for staff and the public and enhancing compliance among licensees and applicants. I'll now pass this over to Chief May to describe the proposed changes.
Thank you, Member Martin. The staff have identified 4 instances in contractors law that require non-substantive or minor updates and are seeking your approval today to submit these items to the Senate Business, Professions, and Economic Development Committee for inclusion in their yearly omnibus bill. The first item, 5A, deletes an obsolete cross-reference in statute related to the installation of fire protection systems. Business and Professions Code 7026.12 provides who's authorized to install fire protection systems, and it contains a cross-reference to Business and Professions Code 7026.13. 7026.13 was repealed in 2017, so accordingly, this cross-reference should be removed to avoid confusion stemming from the citation to a code section that no longer exists. The second item, 5B, deletes a study requirement that has already been completed and submitted to the legislature. SB 465 of 2016 required CSLB to conduct a study regarding whether requiring licensees to report judgments, arbitration awards, or settlement payments resulting from claims for construction defects for rental residential units would be beneficial to consumer protection. CSLB conducted the study and reported the results to the legislature by the January 1, 2018 due date. Because this study requirement has been completed, it's in the legislature's possession, and it remains available on the board's website. It is no longer needed in statute. The third item, 5C, removes an outdated reference to collecting a rescheduling exam fee. As you likely remember, the board's sunset bill requires applicants to pay examination fees and any rescheduling fees directly to the examination provider, PSI. Accordingly, CSLB no longer collects any examination fees, and it is unnecessary to retain language in statute stating that CSLB does not charge a rescheduling fee. Lastly, the fourth item, 5D, updates the Construction Management Education Account Advisory Committee member organizations. Business and Professions Code 7139.3 lists the member organizations that participate in the advisory committee. Two organizations merged, the Engineering and Utility Contractors Association and the Engineering Contractors Association, and it changed its name to the United Contractors. This amendment would simply update the list to reflect these changes, ensuring that all member organizations are accurately reflected in the law. Staff would appreciate the board's support today for including these changes in the 2026 omnibus bill. Back to you, Member Parker.
Thank you, Chief May. Are there any board member comments or questions on an omnibus proposal?
Question, good chair. With regards to the last recommendation about the update, certainly to the name of the organization, but also just the number of members. Does that board, it says here that the board will recommend any coordinating towards, any concerns with related to an even number, for example, of organizations that they recommendation, they're split five to five, about any recommendations in that regard, or?
I don't know if that's a concern, that there's voting that takes place that doesn't add up. I think that would be a more substantive.
There's currently only 10
Yeah.
because this association merged. So we've been dealing with 10 for however long, whenever that merger occurred.
Yeah.
And I think we have encountered, it's a fantastic point, I think we have encountered splits. But it's 10 right now, and it's proposal, it would be substantive to suggest another association be added or another one be deleted. So we just cleared it up in the law, so it's the one association that's been changed.
Thank you.
Thank you. Any other board member comments or questions? Will we call for the vote? Any members of the public would like to comment on the proposal? Seeing none, would I have a motion to propose the omnibus proposal approval? Second. Second, remove second. Any discussion? Seeing none, Katie, would you please do the roll call for the vote?
Again, we should probably ask for public comment.
Oh, after the, okay.
You did.
Yeah, that's okay. After proper, thank you for that.
If anyone has a comment on the motion,
Yeah, thank you.
should be advised.
All right, seeing that, would you please roll call the vote?
Miguel Galarza,
Aye.
Alan Guy, has been excused absence, Ron Phillips,
Aye.
Joel Barton, Amanda Guile, Diana Love, Jacob Lopez, has been excused absence, Michael Mark,
Aye.
Henry Ness,
Aye.
Steve Pinelli,
No.
Joseph Preciado,
Aye.
Jeremy Wayne,
Aye.
Thomas Reeves, has been excused absence, Mary Tiger. Motion passes.
Thank you very much. And this concludes the legislative items today. I'd like to thank Chief May for not giving too many words to trip on. Thank you for your adherence and attention to this proposal. So back to you, everyone.
Thank you. And with that, I'd like to offer a 10-minute break for the board. Second, the board gives tonight. All right. With that, let's go ahead and move on to item F, which is enforcement, beginning on page 151 of your packet. Enforcement will be turning it over to Chair Michael Mark. Michael.
All right, thank you, Chair Galarza. The first item on the enforcement agenda is the enforcement program statistical update. It begins on page 151 of your packet and includes a thorough statistical update. However, at this time, I request Enforcement Chair Steve Grove to provide a few highlights.
Thank you, Enforcement Chair Mark. I have 3 highlights I would like to share this afternoon, beginning at the middle of page 151 of the packet. First highlight is titled Solar Installation Complaint Results in $32,000 settlement. A staff services analyst, SSA, successfully mediated a complaint involving a San Diego consumer who had entered into a power purchase agreement and contract for the installation of solar panels, inverters, and a battery system. The complaint centered on workmanship deficiencies, specifically roof damage sustained during installation, and allegations of misrepresentation regarding the system's energy offset capabilities. The consumer reported substantial water damage to the property and unexpectedly high utility bills as the installed system offset only 77% of their energy usage, contrary to the 100% offset that had been promised. The SSA facilitated a resolution that included a termination of the power purchase agreement and a settlement payment of $32,000 to the consumer to address the property damage. The next highlight is titled Church Construction Project Failure in Paradise, and it's located near the top of page 152. On January 8, 2020, a church representative in Paradise entered into a $318,900 contract with licensed contractor Design Horizons LLC for the construction of a Q cabin kit fourplex intended to support recovery efforts following the 2018 Camp Fire. In case you are not familiar with the Q cabin kits, they are marketed as sustainable disaster resistant structures. A second contract for an additional fourplex was signed on July 29, 2020 for $430,112, bringing the total to $749,012. Subsequent change orders and development costs increased the total contract price to $1,039,968. The complainant paid $744,957 toward the project. Construction began in September 2021, but ceased in February 2023, with over 20 contracted items left incomplete. A corrective contractor later determined that the work performed failed to meet industry standards and did not conform to the approved plans. The estimated cost to correct and complete the project was $700,000, resulting in a $404,989 financial injury. The church also suffered significant operational impacts. Originally, the rental income from the units, estimated at $40,000 annually, was intended to fund a new pastor following the retirement of the current one. After the Camp Fire, the church shifted its focus to housing fire survivors. However, due to the project's failure, the church was left without usable units or rental income. On April 25th, 2023, the church filed a complaint with CSLB. The investigation found sufficient grounds to pursue disciplinary action, and an accusation was filed seeking license revocation. The contractor entered into a stipulated settlement agreement, resulting in license revocation effective August 25th, 2025. Under the terms of the settlement, the contractor is prohibited from applying for license reinstatement for 3 years and was ordered to pay $21,577 in investigative costs and resolve $404,989 in restitution before being eligible for reinstatement. The last highlight I would like to share is at the bottom of page 152 and is titled Responsible Managing Officer Held Responsible. In November 2022, homeowners entered into a $156,846 contract with a licensed swimming pool contractor for the construction of a pool and spa in Calistoga. Subsequent change orders were proposed, totaling an additional $117,585. Despite the license being suspended on September 29, 2023, the company's chief executive officer, or CEO, requested and received a payment of $31,369 on October 17, 2023, without performing any work or delivering any materials. The homeowners ultimately terminated the contract. During the investigation, the CEO admitted to diverting the funds for unrelated purposes, while the responsible managing officer denied any knowledge of or involvement in the project. On July 29, 2024, the investigation was completed and the case was referred to accusation seeking license revocation for multiple business and professions code violations, including failure to exercise direct supervision and control of construction operations, diversion or misapplication of funds, willful or fraudulent conduct causing harm, contracting under a suspended license, and requesting or accepting payment in excess of the value of work performed or materials provided. On July 25th, 2025, the registrar adopted a default decision revoking both the contractor license and the CEO's home improvement salesperson registration, effective August 25th, 2025. To address the criminal violations, the case was also referred to the Napa County District Attorney's Office, and an arrest warrant has been issued for the CEO. There's a typo in the packet that mentions that the arrest warrant was for the RM. It was actually for the CEO. This is another great example of our staff's commitment to work with local prosecutors to address criminal acts. And this concludes my highlight, and now turn back to the meeting.
Great job, Steve. Continuing on with the statistical update, you turn back to page 151. At the top of the page, out of a total of 228 positions within the enforcement division, there were 25 currently vacant positions at the time of this packet. 3 vacancies have since been filled, including the supervising special investigator 1 position. The recruitment process is underway to fill all the remaining vacancies, and interviews have already been conducted for 7 of the vacant positions. The top of page 156, you will find complaint statistics for the period of January 1st, 2025 through October 31st, 2025. A total of 16,892 complaints have been initiated, while with current staffing levels. The optimum maximum enforcement division caseload is 4,895 pending complaints. But as of October 31st, 25, the pending caseload was 5,484. Staff services and analysts assigned to the 2 CSLB intake mediation centers have done a remarkable job of mediating consumer complaints. From January 1st, 2025 to October 31st, 2025, staff's efforts have resulted in $26.5 million in restitution to financially injured parties. Another board goal is to approximately dispose all but 100 complaints within 270 days of receipt. As of October 31st, 2025, 196 complaints exceed the 270-day range. Enforcement supervisors continue to work closely with their staff and provide guidance during regular case strategy, discussions, and monthly case reviews in an effort to reduce the backload of H cases. At the bottom of page 156, You will find information regarding CSLB sponsored arbitration and disciplinary action statistics. More than $2.7 million in restitution have been ordered to injured parties as a result of complaints being referred to the CSLB arbitration. Next, I will provide a brief update on the proactive enforcement, which is conducted by the 27 special investigators assigned to the statewide investigative fraud team, better known as SWIFT. The information begins at the bottom of page 153 of your packet. And we're jumping back and forth. But from January 1st, 2025 to October 31st, 2025, SWIFT conducted 26 undercover sting operations across the state, participated in 352 sweep days, and responded to 524 leads. These tips received from industry and the public helped investigators close 2,252 cases as a result of the operations, with 664 cases resulting in administrative or criminal legal action. Additionally, 891 advisory notices were issued for relatively minor violations. The number of sting operations conducted during this reporting period is considerably lower than usual due to the fact that the SWIFT staff spent a considerable amount of their time assigned to discuss this disaster recovery center supporting survivors of the Southern California wildfires in Pasadena and Los Angeles between January and April. And lastly, when you go to page 159, you will see that the Enforcement Division's Experienced Verification Unit has conducted 378 application investigations during the period of January 1st, 2025 to October 31st, 2025. Of that total, 187 were verified or approved. 73 of these applications were withdrawn and 114 were denied. 4 of the denials are being appealed. Enforcement targets approach to application and investigation is effective and demonstrated by more than 50% not approved. This concludes the enforcement program's statistical update. This is the information only item only, no action is required of the board. Is there any board comments? Is there any public comments? I will say as a chair, enforcement chair, one of the things that's really cool is that earlier in Register of Votes report, he stated there's only 25 complaints and the fires below. So we had kind of like a tale of two fires, unfortunately, and our staff being so proactive down south has really helped make sure that the unlicensed contractors are not doing any work in those wildfire zones. You know, we took a tour down there maybe a year ago, 3 board meetings ago, and we really saw how that disaster recovery centers really help their consumers understand do not hire like unlicensed contractors. And with that is it. Back to the chair.
Before then, with that, we'll move on to item number 2, which is licensing. And with that, I'm going to go between Henry and third, provide a briefing on the licensing update. Henry.
Thank you, Chair Gonzaga. So I'm being the 2025 or I'm the chair of the licensing committee. I'm providing the licensing and testing division today, which is from licensing chief Rebecca. The licensing section begins on page 161 of the board packet. So for the licensing and testing program update agenda, item G1, please turn to page 163 in your packet. Regarding applications, the table on page 165 indicates the number of applications received for new licenses, additional classifications, replacing qualifiers, and home improvement salespersons. As you can see, CSLB received over 12,000 applications in the last quarter, which covers July through October. Almost 5,000 of these applications were for new licenses. 900 were to replace the qualifier on the corporate or LLC license, and a little over 2,000 were from new home improvement salespersons being added to a license. On page 166, you can see that all of our processing times are still close to 2 or under 3 weeks. Staff put in the hard work to process applications, renewals, and other documents each week, and are proud of the processing times posted on the website. Proud of stuff. Moving to page 168, CSLB received over 29,000 renewal applications in the last quarter. In addition, staff report that close to 90 contractors were survivors of the LA fires took advantage of the governor's executive order to defer the renewal fees for a year. Staff began contacting them the first week in December with instructions on how to pay the deferred fees. Page 171 summarizes the work of the judgments unit. Almost 30 million more were recovered to state agencies in the public calendar year 2024 than the year before. Staff are up to date processing judgments, outstanding liabilities, and bond payments of claims. I'll now turn it over to Chief Kara Gagnon for the testing update.
Thank you, Henry. Good afternoon. For the testing update, please turn to page 175 of your board packet. As seen in the table on page 175, CSLB had a record-breaking year with over 59,000 exams being administered to candidates between November 2024 and October 2025. 87 of those exams were taken in the Wilsonville, Oregon Test Center, and 181 were administered in out-of-state test centers. As indicated on page 177, the Exam Development Unit released 2 updated exams between July and October 2025, the C5 Framing and Rough Carpentry and the C35 Lathing and Plastering. In addition, 6 more item banks are complete and being programmed at PSI for a new release date. The Exam Development Unit has 9 additional exams that are currently undergoing the exam development process. EDU has also received the new Title 24 California Building Codes and will be updating all the code-based item banks by January 2026. They are 60% complete as of 2 weeks ago and working on them on a regular basis to bring them all up to speed by the end of January 2026. As mentioned on page 177, staff are continuing to work with our engineering students and PSI test vendor to digitize the booklets for the exams. Currently, all of CSLB's exams, except for the law and business, require a booklet of blueprints, charts, graphs, and other materials, which many of you contractors probably had to have when you were taking your test. And these are used to answer some of the questions on the exam. These are laminated books that are kept at the test centers in secure storage and used just for CSLB trade exams. Staff are in the process of digitizing these booklet images so they can be stored in PSI's computers and used on screen by the candidates. So they can just pop up the picture. Each new image is being pre-tested as it is developed. The C15 flooring and floor covering and the C55 water conditioning exams are both completely digitized and have been released at DCA approved PSI test centers nationwide. So you can now take those 2 exams and your law and business at any DCA approved test center anywhere in our country instead of having to come to California or Wilsonville to take your test. 19 other trades are currently in development and pre-testing for digitizing embedded graphics and embedding these exams. Over time, this is going to save CSLB money on laminating and shipping booklets, and it's going to increase our exam security, not to mention being able to move our exams nationwide. The Spanish exam update begins on page 178. This is part of CSLB's ongoing efforts to reduce language barriers for applicants and licensees, part of licensing strategic plan item 1.1. Between August 2024 and July 2025, over 11,000 Spanish exams were taken by CSLB candidates. Frequently requested are law and business and B general building. And after that, the most common Spanish exams are for the C33 painting and decorating and the C39 roofing trades. CSLB's IT staff are programming a means by which technicians can enter the candidate's language preference when they enter the application data. This programming should be completed by February 2026 and will allow other letters to be translated into Spanish and sent to candidates who are more comfortable using that language. So they can receive letters from CSLB in the language that they're comfortable with instead of getting it in English and having to ask somebody to help them out with it. And I'm going to turn it back to Henry to ask for comments.
Thank you for the update, Chief Carroll. Are there any comments from the board?
I have a comment on Spanish.
Yes.
Is electrical also available?
It is not. When we first looked at it, the top 10 electrical was like number 11 or 12.
Okay,
So it's not been translated yet.
but it's in works.
It's not on the works yet because they only have one exam specialist who can read and write in Spanish. And so if I could get another one we could translate 10 more exams. But until I do, we just had him, who is absolutely wonderful. We are very grateful for. But he's the only one that can work in those exams, create versions, etc. And 10 is an awful lot for one person.
Yeah. I just curious if I.
Yeah.
Thanks.
Just a quick question. And I understand probably a lot of the problems with Spanish language is the writing and interpretation and slang or whatever is
Yeah.
probably hard to just learn which words to use.
Yeah, and so what we did with the exams is we had them translated by a professional company. We didn't know when we did that they translated it into European Spanish, and we got them back and we're like, uh-oh. And again, fortunately, we have this person in exams who's looking at it going, this isn't what we use here in California, and so they are going through the process in all 10 of those current item banks of retranslating it to make sure that the words are Latin American Spanish, which is what we use here in California most often. And then with the letters, we're doing the same thing. We've added instructions to fill out your application, instruction for your waiver application. We've added those to the website, and we've had our own in-house certified bilingual staff do that. So that again, it's more understandable for people. The whole point is to reduce barriers to licensure, not make it more complicated. Yeah.
And I might add, we, several months ago, I had a chance to recognize that group at CSLB. And they told me that the great work they were doing. And what's really cool was the fact that they could toggle different phrases. So, I don't know that phrase in Spanish, but I know it in English.
Yeah.
And so they're able to toggle through things. So hammer means hammer. You know, and so it makes it easier for them to pass with that.
Yeah.
So I thought that was fantastic. They're doing a great job with great team.
Yeah, they are a great team. Thank you.
Like, good, that's probably a good point because there's some items there's probably not a Spanish word for it, so it's in between.
Any other comments? I appreciate that. I mean, it's obviously important. I don't know if this is unique to California, and other groups that have similar scenarios in other states.
Other states have also mentioned it when I talked to them and asked them. Other states have different languages that they have to deal with. French is much more common up in the Northeast and stuff. But same thing, we all want to be able to reach more of our population, more of our candidates.
Yeah, I think it really addresses the barrier to entry conversation.
Yeah.
So
Yeah.
appreciate the work.
So still maybe one question, because I don't know if it makes any sense, but does something like an AI tool, ChatGPT or Claude or something, could they at least do a first pass at stuff, and then we might be able to leverage time by looking or viewing instead of developing translations?
We have looked into that and using that for the initial translation. CSLB is under DCA, which has very strict controls on what access we have to AI because we don't want AI accessing our materials and sharing it with others. So they're still working the bugs out and sort of deciding exactly what and when and where and how we can translate that. Once we do have it translated, like in this case, we had someone else translate it for us and then we have staff work on it. But because the exams are ongoing things, it's not just translated and done. Someone has to read each version, someone has to peer review it, someone has to check it at the test center. That's why I need the Spanish-speaking, Spanish bilingual employees.
Well, the employees for sure, but I'm thinking what the work they do is, could it be, to your point on not being able to cover as much ground on how many exams you have. Could we translate more exams with the same person if the first pass got done by AI and then they were reviewing and editing as opposed to having to do all the work to get more exams covered?
I'm not sure about that, and the reason is because we already have put them out. He didn't translate them himself, but the working on them every day, the meeting with SMEs, because you're fortunate in California, I have many bilingual SMEs who are willing to come in as subject matter experts and work on it. So having those workshops, that kind of thing, that's where his burden comes in doing the work. And 10 exams is a lot for one person. So that's part of our dilemma. But it's something we keep pulling in the back of our mind of, gosh, we wish we could do more. At the moment, we're kind of stopped, but it doesn't mean we won't consider it in the future, especially for electrical and those others that were right there on the list.
That's a great question, actually. everyone sees an AI, there are barriers, but I think it's important to stay on point to make sure that we're going down that path, to at least investigate, make sure that we can. Everybody going? Any other comments from the board? Yeah.
Great licensing.
Yeah.
That's
Any other comments from the board? Are there any public comments? Thank you. We'll move on.
That one over there.
Oh, that one's good. I mean, too.
So next we'll get you we get our Senate issue figured out here. CMA grants for 2026. So please turn to page 179. Item B2, at the end of each year, staff requests a board review and potentially approves grant awards for the construction management and education account. Okay, thank you. And now, so as seen on page 182 this year, the board requested and received approval from the Department of Consumer Affairs to increase disbursement authority from $100,000 to $250,000 in fiscal year 2026-27. This will provide for additional funding for institutions that offer construction management education. This is done each year based on the amount of funds in the account. This year, 5 colleges submitted grant applications, and $225,000 is distributed among 5 public colleges selected by the Construction Management Education Advisory Committee. The members of the committee are listed on page 181. Revenues in the account are from voluntary contributions made by licensees at the time of the license renewal fee payment and are sufficient to support this request.